tied back to the place where accused one was on the stage at the celebration. The suspected firearm cannot be linked to accused one. The spent cartridge cannot be linked to accused one. Nobody reacted in fear in response to accused one's conduct on the stage in the stadium during the celebration. None of the 5 SAPS members on the stage in the stadium during the celebration saw anything untoward on the part of accused one on the stage in the stadium during the celebration. There is no indication of any physical damage caused by any live rounds having been fired by accused one on the stage in the stadium during the celebration. The accused is consequently entitled to be acquitted at the close of the state's case. Put differently, Your Worship, there are 2 points that I wish to highlight. In regard to the submission relating to credibility and taking into account at this stage, the most indicative illustration of this, Your Worship, is when the investigating officer, Colonel Rodney Stephen Swartwell, testified in his examination in chief, Your Worship, and he uttered the following words. Firstly, what appeared to be a firearm, and secondly, that the circumstances of the case had been reconstructed, and he then went further to say, one can see where the shots are being fired on the side of the stage during the reconstruction, and more or less the same area where the cartridge was found as pointed out by the witness. And when questioned, Your Worship, then conceded that there was no reconstruction. He merely looked at photographs of a person pointing something out that he then could not reconcile with the physical structures that were there. It was totally irreconcilable. So that's the point that we make, Your Worship, in relation to credibility and supposition playing an important role at this stage already, because he retracted, in effect, all of that evidence, Your Worship. So there ought not to be any serious regard to that statement by him when he could not substantiate it when challenged on it, and then attributed to the failure to refer in any way to the 5 SAPS protection services members who are on the stage, close protection officers in close proximity to the incidents of the night, not some far off distance or watching a video like these witnesses and like the court. And we want to make it clear, Your Worship, that to put accused one on his defense, that would require him to go testify. Yes, they're all in doubt, they don't know what it is, but I want to tell the court it was a real firearm. And that would be ridiculous to expect that to happen, Your Worship. That's not probable, Your Worship, it's highly improbable, and it's not the way that the presumption of innocence works. He's entitled at this stage to be presumed innocent, insofar as not one particular witness can come to court and say, that which you see there and that which was fired on the stage was, in fact, a firearm. He's thus entitled, Your Worship, at this stage to a discharge. There's nothing that even would go further, even if one couldn't identify it. Let's just say the visuals were unclear, no video was taken, but if one said, and there was the following damage, there was a bullet hole through the sole of a tent, there was that lines up in the trajectory, as the court will often get in lots of cases, of where the spent cartridge was ejected from the firearm, or there's a hole that lines up with where the bullet or projectile would have left the barrel of the firearm. One cannot then say that an actual firearm was fired. It's consistent with there being no case to answer, Your Worship, in relation to the onus of proof in 174. We thus ask for the discharge of the accused number one at this stage, Your Worship. I have no further address unless Your Worship wishes to hear any particular.
Thank you. Advocate Matthews.
Thank you. If I may hand up our original heads of argument, signed by myself as well as my attorney.
Thank you. Thank you.
Thank you, ma'am. Somewhat a different approach to the heads of argument. The first 7 paragraphs deal with the aspect, the legal aspect of a Section 174 application. I'm not going to repeat it because the SC has eloquently placed the correct legal situation before the court. I ever do wish to emphasize the decision of State versus Nkosi and another 2011 volume 2, the South African Criminal Law Reports, at page 482, a decision of the Supreme Court of Appeal. In this particular judgment, handed down by Madam Justice Meyer, Judge of Appeal at that time, it deals with the aspect of there being more than one accused in the witness or having been charged. I say this because even in the decision of the Baksa, there is an indication that the state is entitled to rely on the evidence of a co-accused to implicate another. In the decision of Nkosi, Madam Justice Meyer sets out that the failure to discharge a co-accused because he might be implicated by his co-accused, and there is absolutely no evidence during the trial, whether being in the cross-examination or whether being what has been stated, in itself is undoubtedly denying an accused a fair trial. That decision speaks for itself. Your Worship, I'm sure if you read it, there is no need for me to emphasize the aspects of that. Your Worship, from paragraph 7, we've dealt with the 2 counts which are applicable to accused number 2. It is important to note that the cases of accused number 1 and 2 are completely different in a sense that the counts applicable to accused number 2 relate in essence to the handing over of a firearm to accused number 1 under circumstances where accused number 1 has no authority to possess it. Following from that, for some reason, it is argued by the state that accused number 2 then also places all the occupants of the stadium and the surrounding area in danger. Paragraph 8 of our heads of argument deal with the questions asked of the state in further particulars and the reply given by the state. What I've done, Your Worship, you will see, is that I've set out the questions and I've set out the replies given by the state to both count 4 and to count 6. Now, all that I wish to emphasize from these particular counts is that the state has conceded in the further particulars, as is also evident from the evidence which has been led before the court, that there's no statement by a member of the general public to the effect that they were frightened, and secondly, that there is no statement from any person who can testify that accused number 2 in fact handed over a firearm to accused number 1. Now, this whole case as regards accused number 2 centers around this particular issue. We are not involved or don't want to get involved in credibility of any witnesses. I say so because there are no witnesses whose credibility I can attack, because there are no witnesses who have testified that accused number 2 handed a firearm to accused number 1. I deal in paragraph 10, Your Worship, with the accused's plea at the beginning of the trial. He stated, we place all the elements of the offence in dispute and specifically deny handing a firearm or ammunition to Mr. Malema at any stage. In paragraph 11, I deal with the effect of a plea in terms of section 115, because it's quite obvious that this aspect is going to get lost in the criminal trial. In this matter, Madam Justice Steyn, in the Duma case I've quoted, set out the judgment in Motla Ping by the judge present at the time, Van Rijn, and it sets out the consequences of a plea in terms of section 115. It says, firstly, what is stated in the explanation is not evident. It is a disclosure of the accused's defense. Secondly, the accused exercises an election to make one and should not be coerced into making one. Thirdly, if the accused tenders a plea explanation, then it forms part of the evidential material, and the accused may be cross-examined on the contents of the explanation. D, the plea explanation cannot be used as evidential material in favor of the accused without him testifying under oath. But the next important aspect, throughout the trial, the explanation would operate in favor of the accused in that the state, and it's underlined, is obliged to disprove the defense raised in it. And Madam Justice Steyn indicates that this is a translation of the court's words at 761 to 762E. The original text of Van Rijn JP was in Afrikaans. The importance of this, Your Worship, is that from the outset of this particular case, accused number 2 has placed in dispute the fact that he ever handed a firearm or any other object, for that matter, to accused number 1. The duty was on the state, and it was obliged to disprove that defense. Now, paragraph 12 and 13, 14 deals with certain aspects where indeed I deal with the aspect that there is no evidence that has been led that accused number 3 ever handed a firearm to Mr. Malema at any stage during that evening. The closest we've got in this case is Mrs. Governor, who made an assumption that because accused number 2 was on the stage, close to the vicinity of Mr. Malema after the shooting, she assumed that Mr. Malema had handed the firearm back to accused number 2. But just for the moment, presume we can assume that. That is not the offense. That is not the offense the accused is charged with. The offense is the accused is charged with handing a firearm to Mr. Malema under circumstances where Mr. Malema was not legally entitled to possess that firearm. While I'm busy with that, what evidence is there before this court that he wasn't in fact legally entitled to possess? Absolutely nothing. Now, you will see in the further particulars, and I realize Mr. Caesar only came into this case at a later stage. He seemed quite surprised about the cross-examination of the person by the name of Larry Mavundla. But if one looks at the further particulars, then the state was making the allegation from the outset that the firearm in question had been booked out to Mr. Larry Mavundla, that he was at that stadium on the night in question and was in fact in East London for some time prior to that, because they had basically cell phones. The state agency was on the stage. Now, no statement has been obtained from Mr. Mavundla as to what happened. Did he have his firearm on the night in question? And who did he hand it to, or who did he give it to? We have the evidence of Colonel Janssen, who met Mr. Mavundla in Durban. Mr. Mavundla said, yes, the firearm you're looking for, because I'm told we need to hand over our firearm. And Colonel Janssen at that stage testified that Mr. Mavundla said to him, but this firearm was not in East London on the evening in question. So this is not something that has been sucked out of somebody's thumb from the very outset of this particular case. Mavundla told Colonel Janssen that this was my firearm, it wasn't in East London on the night in question. Whether or not it was, of course, it's got nothing to do with us. Because even if it was here, the state has not produced any evidence to show that we handed it to Mr. Malema. The further particulars alleged and following. Accused number 2 is seen at the back of the stage carrying a rifle. Now, I want your worship just to search your memory, and I know it's very good. And the notes your worship has taken in this case are very accurate. Whether your worship has any evidence that accused number 2 is seen at the back of the stage carrying a rifle. Secondly, it's alleged Mr. Snyman is the only white male on the stage before and after the shooting. Again, we search our mind, there is no such evidence. Mr. Snyman handed a rifle that belonged to tactical security to Mr. Malema. Now, where in heaven's name did the state in its further particulars get that information from? Unless there's a witness they have that they've decided not to call, who can come and tell us, I was there, I saw Mr. Snyman hand the rifle to Mr. Malema. Because with the greatest of respect, we have heard absolutely no evidence to this effect. Then the state alleged in the further particular, Snyman was present when the shots were fired. There's no evidence that he was present when his shots were fired. Your Worship, why I say we don't even have to deal with aspects of credibility is because there's nothing to compare. There's no witness who can say whether it's credible or not. Because there is simply nobody who has come before this court who can substantiate the claim that Snyman handed the firearm to Mr. Malema. If indeed it is a firearm. Now, His Lordship Mr. Justice Nugent in the Lebaxa case made the following remark. He said there should be reasonable and probable cause to believe that the accused is guilty of an offence before a prosecution is initiated. You cannot make assumptions and prosecute a man in the hope that something might come out during the trial which is going to implicate you. Prior to you prosecuting him, you must have prima facie evidence that he has committed the offence in question before you charge anybody. And I submit with the greatest of respect, and we will see if the state can stand up here today and honestly tell you that it has produced any witness that Snyman handed the firearm to Mr. Malema. I did glance through Mr. Caesar's heads of argument, and I see he has quoted the old classicus of State versus Blom, dealing with the inferences one may draw from certain Blom starts off with a very important proviso, and that is the word proven facts. If one wants to draw an inference, it can only be drawn from proven facts. It has a second leg. Those proven facts must also be the only reasonable inference that can be drawn. But at the start off is that there must be proven fact. There's no proven fact yet. As I've stated, Your Worship, there is one concern I have, is that we have two accused persons before court. This is a highly political case. But under the circumstances, it is quite obvious and clear that neither Mr. Snyman is implicating Mr. Malema or Mr. Malema is implicating Mr. Snyman. And under those circumstances, as indicated by Madam Justice Maya, Judge of Appeal, as she then was, it would be a complete, as she stated, if I may just get her wording, I don't want to misquote her. It would undoubtedly deny him a fair trial if he was not granted a discharge of that state. Thank you, ma'am.
Thank you. Advocate Caesar at this stage. I can't even see.
Thank you, Worship. I also may hand in a copy of my original heads to the court. I have provided my learned colleagues
Thank you.
with copies of the heads.
So are you saying you're ready to proceed and reply?
That's correct, Your Worship. I have drafted the heads in anticipation of what might be argued today, so I'm ready to proceed.
Okay, just a minute. Second, I'll be with you now, Advocate Caesar. Thank you. You may proceed.
Thank you, Your Worship. The state is indeed opposing the discharge of the accused as of burglary. The evidence presented by the state during the trial is overwhelming against the accused. We should state yet the oral evidence of several witnesses. Such evidence was corroborated and substantiated with real evidence in the form of the video audio clippings depicting accused number 1 firing several shots in the air. A spent cartridge that was found at the scene, which later linked the firearm owned by the company of accused number 2 to that cartridge case in question. Accused 2 is also visible in the video footage, where he is seen approaching accused number 1 after the shots were fired. This happened in a matter of split seconds. Accused 1 and accused 2 are seen walking towards each other. And thereafter, accused number 2 moves away from accused number 1. Subsequently thereafter, accused number 1 is no longer in possession of the said firearm. A more detailed discussion will then follow below. The section 174 in the context of this trial have already been argued by both counsel for accused number 1 and accused number 2. I do not wish to repeat. The principles are the same relating to what has been said in terms of section 174, discharge. In respect of this particular section, the sole discretion whether to discharge an accused is upon your worship. Where more than one accused is charged with the same offense, the court may refuse a discharge or to discharge one of them if it is in the interest of justice to do so. It is our submission that it is indeed in the interest of justice, more specifically relating to accused number 2, the discharge that has been requested and the facts that have been laid before your worship, and I will substantiate my argument to your worship. On page 3, at paragraph 10 of my heads, I want to refer the court to State versus Bodyguard and another, in brackets 2, 194, in brackets 1, BCLR, 10, Saga, in brackets, the question of fundamental rights in section 174 was considered in respect of the Bill of Rights of the erstwhile Republic of Saga, where Heath J. said the following would probably give effect to the wishes of society and the purpose of the Constitution. 1, an innocent person, as far as possible, must never be convicted of a crime. I am in full agreement with that. The conviction of a guilty person must be obtained with the best possible endeavors. The right to remain silent and the satisfaction of the onus which is on the state must be satisfied as far as possible. For the rights of an accused is very important, but the rights of the community to see that justice is done is equally as important. To achieve these goals, instruments should be used in such a way that justice is done to everybody. These 6 principles are indeed very important if you look at the issues that has been raised in this particular matter. This is why I would submit that very few courts are placed in the position that your worship, this court has been placed with real evidence, real video footages from different places, the house, as well as the viral footage. A real firearm that was brought to this court belonging to the company of accused number 2. A real spent cartridge was brought for the court to examine, to look at it, look at the firearm, look at the footage. I'm of the view in this my submission that the court was placed in the best position to assess the evidence, to look at it, and make its findings in this regard. Bishop, I summarized the evidence of all the witnesses. Mr. Otis already went through it. What is of importance from this particular summary that is the 15.2, Colonel Gamlana Mkwali, the one that opened the criminal case, that was present on the evening in question. He testified that he didn't see anything what transpired, but he was later sent this particular viral footage, of which he was of the view that in an investigation a docket must be opened and an investigation must commence. What's also the importance of this evidence is that he said there were no prior agreements between him or any member of the party or any of the accused that assimilation of a firearm would be firing shots was discussed, and he would have to give permission in order for that to happen. I want to also refer the court to the evidence of Ms. Ntombekile Mankomo. She's the one that found the specific spent cartridge. That was the cleaner that was there 2 days after the incident on the 30th of July. What's important of her evidence, usually this is just a normal, ordinary person that was performing her duties on the day in question. She's got no interest in this particular matter. She didn't even know what was that spent cartridge that she picked up. As a result, she asked Mr. Kumalo, who was working for BCM, what this was. He took a photo of the spent cartridge and then informed her that she must hand it over to her supervisor, which she did. This witness, as unsophisticated as she was extremely honest to such an extent that the evidence remained intact. What is also of importance from her evidence is the issue that was raised as to where exactly this firearm and the possibilities and impossible probabilities. Usually, even if she found that spent cartridge in the air, the fact of the matter is that it was found in the area or in the stadium where these shots were fired. Where she found it, in my submission, is irrelevant. What's of importance is that coincidentally, it was found on the side which one can see, on the direction where these shots were fired into. What is also of importance that the incident occurred on the 28th of July. That was in the evening. The 29th, that stadium was still, or the stage, that is the word I'm looking for, was still there on the 29th. It wasn't dismantled. They just started to dismantle it on the 29th and on the 30th. My submission is this is really irrelevant as to where this spent cartridge was found. The fact of the matter is that it was found, whether it was in the air or on the other side of the stadium, on the left or the right side, it was found on the stadium. I want to take the court then secondly to page 6 on paragraph 15.7, the evidence of Colonel Johnson that was also mentioned by counsel for accused number 2. What is of importance that when he arrived there, visiting the premises of accused number 2's business, instead of all the many firearms that were there, he was given, or 2 firearms were produced, the one that was linked to this particular incident, and then a 9mm Glock. If one look at the footages, a handgun was also, shots were also fired from a handgun, despite the fact that the accused were not charged for that offense. It cannot be coincidence that accused number 2 knew at that stage that these were the firearms. He had many firearms on their premises that the police came there to look for. And the reason this was done is my submission that accused 2 did not want to disrupt his business because he suspected that all the firearms will be taken by the police for ballistic test. As a result, that's why his attorney had to intervene so that batches could be taken, because it would have been disrupted. His business would have been disrupted if all the firearms were taken for ballistic testing. The question then arises, how did he know that these were the 2 specific firearms that were the police were searching for? And coincidentally, one of their firearms tested positive to that particular scene here in Ndansane at the Sisha Dukasha Stadium. To me, it's very important. Accused number 2 knew because he was there and he participated in what transpired on that evening in question. He knew that was the first firearms that were used by Mr. Malema, both the 9mm Glock and the 2.223 firearm that was brought to fire this court, where Mr. Gadleka linked that firearm to that spent cartridge. We have now the firearm that was used. We've got the spent cartridge. I'm going to the video footage related to this. What is also of importance is the evidence of Colonel Gadleka, that he was very objective in his evidence. He's an experienced colonel that testified how he managed to link, despite the fact that the breech block of this firearm and the firing pin of this firearm was removed. In order to affect the results, he was still able to find 3 points and match that spent cartridge to the firearm that belongs to accused number 2. I've heard the cross-examination of counsel for the accused relating to the breech block and the firing pin and why the accused was not charged for defeating the act. That thought did cross my mind. If I had more time to peruse everything, I would have charged him for that. It's clear this was done for the sole purpose to defeat the ends of justice. You should then look at the evidence of Ashley Singh. I'm not going to go through it. Samuel Kwata and Sibusiso Ngobo relating to the video house footage. What is important from this specific footage of the gear house, it confirms the incident did transpire as per the viral footage. The viral footage was just taken from a different angle. From what I could view, it was taken from that particular stage where the incident occurred. But if you look at both footages, even the singing the song that was sang at that particular time is the exact same one in both footages. The court can safely exclude that there was any tampering or that there was any amendments or alterations to the viral footage as counsel wanted to allude to. To do that would just amount to sheer speculation, whereas the year of footage have already been authenticated. We have argued this issue relating to admissibility thoroughly on the previous occasion. That was as bolted already. The only issue that the court must decide on is the relevance of those particular videos, not their authenticity. It has been stated in many case laws, which I've mentioned before. It has been confirmed by the Supreme Court of Appeal. Your Worship, I only want to deal with the evidence now of Colonel Rodney Stephen Swartboy, who's the investigating officer, and how he explained what unfolded during his investigation. The only issue that is really of importance from this evidence is the chain relating to the firearm that was linked, how he found the firearm at Brighton Beach from Captain Creer and brought it to the ballistic section here in Kabeja for ballistic tests to be conducted. Much has been made of the fact that he didn't disclose that the close protectors were on the scene, and Your Worship, it's not our job. Our job is to prove our case. The information was disclosed to the defense. They must do their work. It wasn't hidden from them. Everything that was put to Colonel in this regard, Colonel Swartboy, it's not our work to do that. Our work is to disclose all the information, those that benefit the accused and those that are against them. Your Worship, so far as his evidence is concerned, it was also said as to the close protectors, didn't see, they were on the stage and so on. It is clear from this, Your Worship, one take into consideration accused number one's own version that he fired shots on the night in question. During that incident, it's clear somebody's lying here as to whether either the close protectors were there and they didn't see, or they were not there. Because in his own version contradicts exactly that point, that this incident happened as described in the video footage. They were either not present, or they didn't observe anything, or they were deliberately untruthful. It leads to the inescapable conclusion that they were untruthful as to what transpired on the night if they were on that stage. Because accused number one confirms this incident. It did happen. He just says it's a toy firearm. We're saying it's a real firearm. It also begs the question, Your Worship, that it was raised that we didn't have any eyewitnesses and so on. If the members of the South African Police Service that were close protectors on that evening did not want to or were not prepared to come and testify, how can we expect an ordinary member of the public that were there to come here and say that is exactly what we have seen? And also take into consideration most of the people that were there were EFF supporters. So it's not strange that no witness came forward to come and testify, as been put like by my counsel for accused number 2, that this case is highly political. What is important about this, it is evident from the evidence from Colonel Nkwali, from Warrant Officer Becker, Colonel Gwadleka, Colonel Nzupu, Warrant Officer Steenkamp, Captain Bota, Captain Governor, and Colonel Swartberg, all of them being experienced members of the South African Police Services that uses and utilize firearms, a tool of their trade, talking about this muzzle flash they observed on the video footage. They were not prepared to commit that this was indeed a real firearm, but this was an issue that kept on being raised about the muzzle flash, which they observed during. The only reason why they couldn't commit to that because none of them are ballistic experts, but Mr. Gwadleka already confirmed that this firearm was indeed there and that firearm was used during this incident. It's linked to that cartridge. Bishop, the submissions made by accused number 1 and 2 during the cross-examination of Mr. Singh, Mr. Kwata, relating to the issues of the footages, like I've said, the Bishop can safely accept that footage is authentic. There wasn't every tampering. To do anything else would be a speculation of Bishop, insofar as the witness is concerned, that we don't have any witness, I think we brought to your worship the best witness ever. It's a silent witness in the form of those video footage. It's better than an actual eyewitness's evidence, which enabled the court to see what exactly transpired during the incident, as the contents thereof is unbiased, it's unemotional, it does not exaggerate, nor does it take any sides, and it doesn't have the preconceived perceptions, does not have any of the fallible qualities that one can attribute to human beings. It doesn't fabricate a version. It just shows what it has recorded during the incident on the press of a button. What better witness would your worship would want in the form than that witness? Bishop, it was said that the state didn't even prove its case because there was no witness, there was no this and that. Beyond reasonable doubt was described by Kenny J. in the matter of Miller versus Minister of Pensions 1942, or ER at page 372 as follows: the degree is well settled. It need not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean proof, does not mean beyond reasonable doubt or beyond the shadow of a doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect justice. If the evidence is so strong against a man as to leave only a remote possibility in his favor, in which can be dismissed with a sentence, of course, it is possible, but not probable. The case is proved beyond reasonable doubt, but nothing short of that will surface. 1 + 1 = 2, plus another 1 = 3. Your worship got the video footage, your worship got the spent cartridge, your worship's got the actual firearm. You've observed it. It's my submission that that is proof beyond reasonable doubt. Bishop, I submit the dictum that I've just stated is applicable and relevant to this case. It's highly improbable that the accused one fired several shots with a toy firearm or a movie gun. If the court considers that no prior discussions took place with the scanner in Kwale. If one look at the footage, you don't need to have been an expert to see it looks similar to the actual firearm that was produced here in court. If you look at length and size, it was already confirmed by Mr. Guadaleka that indeed a real firearm fired that spent cartridge on the night in question. Also of importance is if one look at the actions on the video of accused number one, he doesn't with this toy firearm fire into the crowd or fire to his gentleman that was on the stage with him. No, he takes a secluded place, moves to the right side of the stage, the far right, and he fires the shots there. Where there were either no supporters or very minimal supporters. If this was a toy firearm, he could have just moved it around, fired to everybody else because he was showing it off. Why didn't he do that? That's an issue the court must also consider if one look at the actions of accused number one on the night in question, or it was clear that that was a firearm if one look at his actions. This is why I have stated, and it's already been stated by counsel that he spoke about R versus Brown. The only reasonable inference the court can draw is that indeed it was a real firearm, because this is the issue. Insofar as accused number two is concerned, one can clearly see from the video footage there's a discussion between him and accused number one. Accused number one moves towards him, smiling, both of them. Moves towards him, give what looks to appear that he hand over the firearm. The court can draw an inference. After that, accused number two is seen moved away. Accused number one is no longer in possession of the firearm. What other reasonable inference can be drawn from that? If accused number two was not the bodyguard of accused number one on that evening in question, what other purpose would he have been here in East London with accused number one? The court is not obliged to indulge in a conjecture and to find the answer for every possible inference if one looked at this incident. You're not required to seek speculative explanation for conduct which on itself, on the face of it, is incriminating. It's submitted, Your Worship, that the evidence that was presented before court is strong, and that the application for a discharge once and can safely be dismissed in respect of both accused. That's our submission.
Thank you, Advocate Caesar. Sorry, Advocate, I'll just be with you now. Is there a reply by...
Yes, yes.
Okay, the light is blinding me, so it's impossible to look up or see anyone or even the time. Thank you. I couldn't, yes, thank you. At least I can look. I couldn't look up at all, so. You want to reply now or after the tea adjournment, which is 11:15, then we'll take tea 10:30 to 10:45, or we can continue to 10:45 and then take it from there to 11.
I'm in your worship sense. I
No,
could
no.
reply, but if there's a need for a body break, if your worship, then perhaps it is an opportune time to take the tea adjournment, and I can reply after the tea adjournment.
I'll hear from other court officials. Advocate Caesar, you wish a break?
More instructions may also come from the accused towards it's a appropriate time.
Advocate Matthew is in agreement with the sentiments of your colleagues. Okay, just one aspect.